Hello, everyone. My name is Sarah Roubidoux Lawson. I am of counsel at Schwabe, Williamson, and Wyatt, and an enrolled member of the Iowa Tribe of Kansas and Nebraska. This is your litigation update for the Tribal Lands Staff National Conference 2021. We're going to start with Supreme Court cases that have come out within the last year. The first case, of course, is McGirt versus Oklahoma. I'm not going to spend a whole lot of time on this case because we have a whole panel on it during the conference. But McGirt versus Oklahoma was a challenge to the state court criminal prosecution of an Indian who committed a crime within the boundaries of the Muskogee Creek Nation. The state of Oklahoma argued that the Muskogee Creek Nation reservation had been diminished or disestablished over time. The United States Supreme Court held that Congress established the reservation, that the allotment agreement with the tribe did not terminate the reservation, that Congress's intrusions on tribal self-governance did not disestablish the reservation, that historical practices are insufficient to prove disestablishment, and that the Creek Nation's fee title ownership of land does not make it a dependent Indian community. Based on the court's ruling in McGirt versus Oklahoma, the state court criminal prosecution of Jimcy McGirt was improper and invalid, and that the Muskogee Creek Nation and the federal government were the only entities that were the proper entities to undertake a criminal prosecution of Mr. McGirt. We're going to talk about lower court cases now. So the first case is McMahon versus CHEMEHUEVI tribe. This is tribal members who challenged traffic violations by the county sheriff within the tribe's reservation. In 1853, after California gained statehood, Congress ordered a survey of public lands and granted the state title to sections 36 and 16 of each township. The act specifically excluded from that grant any land that was in the occupation or possession of any Indian tribe. The Surveyor General approved a survey of the land at issue in this case in 1895. But while that survey was being conducted, Congress enacted the Mission Indian Relief Act, ordering the Secretary of the Interior to select a reservation for each California Mission Indian tribe. The reservations were to include, as far as practicable, the lands and villages which have been within the actual occupation and possession of said Indians. In 1907, C.E. Kelsey issued a report to the Commissioner of Indian Affairs identifying land to be included in the reservation. In an executive order in 1907, the Secretary then directed that the lands referred to by Kelsey and the Commissioner be withdrawn from all form of settlement and therefore created the reservation. The state of California argued that the 1907 order was void ab initio because Section 36 had already been deeded to California. The 1853 Act that excluded any land in occupation or possession of any Indian tribe. The court held that Section 36 is within the reservation for purposes of the Major Crimes Act, and the court found that the state was not able to properly ticket tribal members who were on tribal lands. The next case was FMC versus Shoshone-Bannock tribes. This was a challenge to tribal regulatory jurisdiction over a non-Indian company that operated on fee land within the boundaries of the reservation. So FMC had operated a phosphorus plant on fee land within the boundaries of the Shoshone-Bannock tribes reservation. FMC had agreed to tribal permitting under a settlement with the EPA for violations of CERCLA and RCRA. The tribal permit fee authorized FMC to store hazardous waste on the property. FMC stopped paying the fee, alleging that the tribe lacked jurisdiction under the test under the US versus Montana test. That test, as we all know, holds that tribes only have jurisdiction over non-Indians on fee land within the boundaries of the reservation if there is a contractual relationship between the tribe and the non-Indian, or if the non-Indian's conduct threatens the health, safety, welfare, and political integrity of the tribe. The Court of Appeals for the Ninth Circuit found that the tribe had regulatory jurisdiction under the Montana test. FMC then appealed to the US Supreme Court, but the Supreme Court declined to hear the case earlier this year. Next, we have SWINOMISH Tribal Community versus BNSF Railway. This is a trespass action brought by a tribe against BNSF. Over 100 years ago, a predecessor to BNSF built a railroad across the reservation. In the 70s, the tribe in the United States brought suit against the railroad for trespass. That litigation eventually resulted in a settlement agreement and an easement agreement. As a result of those agreements, BNSF applied for and obtained a right-of-way across the reservation by the Bureau of Indian Affairs under the 1948 Rights-of-Way Act. The right-of-way incorporates the terms of the easement agreement. BNSF agreed to a daily maximum of 1 train each direction with a maximum number of rail cars unless the tribe agreed in writing to increase that number. In 2011, the tribe learned that BNSF was violating the terms of the right-of-way easement by running more trains and cars across the reservation than was permitted by the terms of the easement. BNSF had also failed to submit to the tribe any required annual cargo reports. The tribe requested that BNSF comply with the terms of the agreement, but BNSF refused. The tribe then sued BNSF in federal district court. This was an interlocutory appeal where BNSF argued that the district court, BNSF had argued in the district court that the Interstate Commerce Commission Termination Act, or the ICCTA, preempted the easement agreement. The district court disagreed, and BNSF filed an interlocutory appeal. The Court of Appeals held that the ICCTA does not repeal the Indian Rights-of-Way Act, and that enforcement of the easement agreement was not an unreasonable interference with rail transportation, and thus injunctive relief was not impliedly preempted by the ICCTA. The court further held that the ICCTA abrogates neither the general treaty-based federal common law rights of tribes to exclude non-Indians from Indian lands, nor the explicit right of the tribe to exclude as contained in the Treaty of Point Elliott, to which the tribe was a signatory. The next case is the Confederated Salish and Kootenai tribes versus Lake County Board of Commissioners. This is another trespass case involving rights-of-way and a quiet title action brought by the tribe. The tribes challenged the County Board of Commissioners' permitting of a road through the reservation. Under the 1855 Lame Bull and Hellgate treaties, non-Indian settlers could reside within the reservation boundaries only with the tribe's permission. The treaties provided that if necessary for the public convenience, roads may be run through the reservation and rights-of-way with free access from the same to the nearest public highway is secured to them. The Flathead Allotment Act of 1904 authorized the executive branch to survey and allot lands within the reservation. Congress then amended the Flathead Allotment Act in its 1906 Indian Appropriations Bill to provide for the platting and dispensation of town sites on the Flathead Reservation. A bill writer named specific pre-existing settlements on the reservation and further authorized the Secretary of the Interior to locate additional necessary and convenient town sites. The Secretary was then to survey, lay out, and plat the selected town sites into lots, streets, alleys, and parks. In 1910, the Interior Department approved the withdrawal of the Big Arm town site from the reservation. The site was platted in 1913, but approximately 75 lots in the Big Arm settlement never sold. The Department of the Interior finally agreed to restore those surplus lands in Big Arm back to the tribe in 1956 and issued a restoration order returning to the tribes the remaining 260 unsold lots. The Lake County Board of Commissioners approved a road through Big Arm more recently. This would have connected an existing gravel road to a proposed RV resort. The tribes placed a gate blocking access to that RV resort, and the tribe alleged that title had not transferred under the Flathead Allotment Act. The court found that, yes, title had not transferred under the Flathead Allotment Act, that Lake County does not have jurisdiction to permit the construction of a new road, that the treaties do not give the county the right to build roads through the reservation, and that litigation was not foreclosed by an earlier Court of Claims case. GRONDAL versus Mill Bay Members Association. This is a dispute over campsite memberships on Indian trust land that were purchased by non-Indians. This is the Moses allotment on the Colville Reservation in Washington State. The Moses allotment was allotted to Wapito John in 1907. After Wapito John passed, his interests were inherited by his heirs and the allotment became fractionated. In 1984, one of the fractionated co-owners obtained a master lease over the property, with 64% of the other allottees agreeing to this master lease. That fractionated landowner then began developing an RV park called the Mill Bay RV Resort. Camping memberships were sold to anyone interested in using the Mill Bay Resort for recreational purposes. In 1985, the fractionated landowner, who was the lessee, sent a letter to the Bureau of Indian Affairs indicating that they wished to exercise the option to renew their master lease well in advance of the initial 25-year lease term. The Bureau of Indian Affairs never communicated with the lessee to notify him about the status of the lease renewal. BIA did not examine or question the lease renewal until 2007. BIA then sent a letter to the lessee's successor in interest, Wapito Heritage, stating its position that the lease option had never been properly exercised. Under the lease, according to the Bureau of Indian Affairs, the extension had to be communicated to the landowners as the lessors of the property and not to the Colville agency. The Ninth Circuit found that the master lease was not renewed properly and that it had expired in 2009. The Mill Bay members, so the non-Indians who had purchased the camping memberships, argued a new case in district court that the land was not trust land. So in this decision, the court found that yes, the land was held in trust for the benefit of individual Indians, and that the Mill Bay Resort campsite purchasers' right to use the land had expired along with the lease. Oneida Nation versus Village of Hobart. This is another reservation boundaries case that sort of relies on McGirt. So the tribe brought suit against the Village of Hobart, alleging the city's enforcement, or challenging the city's enforcement of a special events permit. The Oneida Nation hosts the annual Big Apple Fest on land that is partially located in the Village of Hobart. If you're familiar at all with the Oneida Reservation, the Village of Hobart is an incorporated city that is entirely within the boundaries of the Oneida Reservation. This is on the Apple Festival is on tribally owned lands that happen to be both within the boundaries of the reservation and partially within the boundaries of the Village of Hobart. In 2016, the village demanded that the nation obtain a permit under the village ordinance and submit to some of the village's laws. The village argued that the reservation was diminished piece by piece when Congress allowed the reservation or allotted the reservation among individual tribal members and allowed the land to be sold to non-Indians. The district court initially agreed and granted summary judgment in favor of the village. The reservation was created by treaty, however, and it cannot be diminished or disestablished by actions alone. It can only be diminished or disestablished by Congress. And Congress had not done anything to disestablish the Oneida Reservation. So the court, in interpreting McGirt and the framework established by Solomon v. Bartlett, found that the reservation had not been disestablished or diminished at all. The Oneida Nation prevailed under the Solomon framework with adjustments that were made by the court pursuant to the US Supreme Court's decision in McGirt. So the court then found that the village lacked authority to enforce a permit ordinance and the nation's reservation had not been diminished or disestablished. Mille Lacs Band of Ojibwe versus County of Mille Lacs. This is another case that deals with the boundaries of the reservation and looks at whether the reservation had been disestablished or diminished. So the tribe and the county are in dispute about the extent of the tribe's authority to conduct law enforcement activities within the boundaries of the reservation. The county claims that the tribe's reservation boundaries were disestablished or diminished. And if the reservation was not disestablished or diminished, the tribe has full authority over lands within the boundaries of the reservation. Next case. Perkins versus Commissioner of the Internal Revenue Service. So this is a tribal member challenge to the IRS income tax notice of deficiency. This is a tribal member involved in mining sand and gravel from tribally owned lands. These are not lands that the tribal member actually owns in trust or in fee for themselves. This is under a lease with the tribe. The Internal Revenue Service issued a notice of deficiency for failure to include income received from sand and gravel mining. The tribal member alleged that this is income received from Indian land and therefore exempt from federal income tax. The court found that the tribal member's income was derived from the tribe's land and is therefore taxable and is not exempt under either the treaty or any previous IRS rulings. Cayuga Indian Nation of New York versus Seneca County. This is a question as to whether tribal sovereign immunity prevents the foreclosure of property owned by the tribe for non-payment of real estate taxes. So in 2007, the Cayuga purchased several parcels of land in Seneca County, and the Cayugas then refused to pay real property taxes levied by Seneca County against the properties. In 2010, the county initiated foreclosure proceedings under the New York real property law. And in response, the tribe sued the county in federal district court, asserting that the foreclosure actions were barred by the doctrine of tribal sovereign immunity from suit. Note that these are fee parcels that we're dealing with here, are not necessarily trust lands. The lower court agreed that tribal sovereign immunity prohibited the suit, and then the county appealed. The court found that foreclosure actions do not seek to establish county rights in real estate. Rather, because foreclosure actions seek to seize properties as a remedy for the non-payment of taxes, the proceedings are at best seen as the functional equivalent of an action to execute a money judgment. As such, they lie within the category of suits from which sovereigns are traditionally immune under common law, and the existence or not of an immovable property exception to tribal sovereign immunity is of no moment. So the court found that the county could not foreclose against parcels owned in fee by the Cayuga tribe, because tribal sovereign immunity prevented the county from suing the tribe for the non-payment of taxes. Solonex versus Bernhardt. Solonex challenged the decision of the Department of Interior to cancel an oil and gas lease in the Badger Two Medicine area. The Badger Two Medicine area has cultural and religious significance to the Blackfeet tribe. Department of Interior canceled the lease for failure to conduct a proper analysis under the National Environmental Policy Act and an analysis under the National Historic Preservation Act prior to issuance of the lease. Solonex claimed that the Department of Interior failed to consider their reliance interest in the lease. And the district court granted summary judgment in favor of Solonex. The Court of Appeals then vacated and remanded the district court's decision. Gardner versus Long. This is a case that takes place in Utah, in Uinta County. An individual Indian landowner sought to prevent the county treasurer from proceeding with the tax foreclosure on his Indian trust land. As part of the proceedings here, the Bureau of Indian Affairs affirmed that the land is actually held in trust. A preliminary injunction was denied, but I don't know that the county treasurer will be able to proceed because as an Indian trust allotment, it is not subject to taxation by the county. Right, and FEDA trust cases. Jackson versus United States. So this is an individual tribal member appeal of a Bureau of Indian Affairs decision not to acquire land in trust. There was a previous court order that entitled tribal members to have land taken back into trust by the Bureau of Indian Affairs. And the Bureau of Indian Affairs rejected several applications to take the land into trust prior to the death of the original applicant. Cherokee Nation versus Bernhardt. This is a Cherokee Nation challenge to the Bureau of Indian Affairs taking land into trust for gaming purposes for the United Keetoowah Band of Cherokee Indians. The Cherokee Nation alleged that the Bureau of Indian Affairs' action in taking this land into trust was arbitrary and capricious. The Cherokee Nation alleged that the agency failed to consider an important aspect of the decision, that their explanation for the decision ran counter to the evidence, that the agency failed to base its decision on relevant factors, or that the agency made a clear error of judgment. The court agreed that the acquisition was, in this particular case, arbitrary and capricious, and reversed the Bureau of Indian Affairs' acquisition of this land for gaming purposes on behalf of the United Kituwa Band of Cherokee. Eastern Band of Cherokee versus DOI. So this is an Eastern Band of Cherokee challenge to the Bureau of Indian Affairs taking land into trust for the Catawba Indian Nation. EBCI asked the court for an injunction to prevent the land transfer, so to prevent the Bureau of Indian Affairs from actually taking the land into trust. The tribe, EBCI, claimed that Interior's decision to take the land into trust ran contrary to a statute codifying a 1993 settlement agreement between South Carolina and the Catawba. The agency's decision, according to the tribe, was therefore arbitrary and capricious and contrary to law. The tribe also claimed that the BIA did not make reasonable efforts to consult with EBCI in good faith during the environmental review process and the National Historic Preservation Analysis in violation of NEPA. The court disagreed. They denied EBCI's motion for a preliminary injunction. MASHPEE Wampanoag versus BERNHARDT. This is another fee to trust case. I'm sure many of you have heard of this one. This is an ongoing dispute between the tribe and Department of Interior. In this particular decision that was issued earlier in 2020, had to do with the court ordering supplemental briefing on withdrawal of the M opinion. So the Department of the Solicitor in March 9th, or on March 9th, 2020, withdrew Solicitor's opinion M37029, or the M opinion. This was the M opinion that had been the agency's two-part procedure for determining whether a tribe was under federal jurisdiction in 1934. After withdrawing the M opinion, the solicitor issued a memorandum outlining a new four-part test. The government was asking the court to defer to its application of a test that the agency itself had now deemed was contrary to law. The court was very upset with hearing that Department of Interior had withdrawn the two-part determination M opinion. The court said, the government did not bring this change to the court's attention and discuss its relevance or lack thereof to the pending motions for summary judgment and a preliminary injunction. The court was left to discover this change on its own less than 1 week before oral argument on the very question of whether the agency's application of the M opinion was arbitrary, capricious, an abuse of discretion, or contrary to law. The government's failure to bring its withdrawal of the M opinion to the court's attention means that the tribe may well have been unaware of the change itself. Not only did the government fail to bring the withdrawal of the M opinion to the court's attention when it should have, almost 2 months ago when the solicitor deemed it contrary to law, but astonishingly, the flurry of activity that has developed in this case over the past month also did not prompt the government to act. Less than 2 weeks after the solicitor withdrew the M opinion as contrary to law, BIA advised the tribe that it was taking the tribe's reservation lands out of trust and revoking the tribe's reservation proclamation. There was no mention of the fact that the agency had just withdrawn its M opinion. And so the court ordered further briefing. Hardwick versus United States. This is a challenge to the BIA's decision not to take land into trust for the Buena Vista Rancheria through a mandatory trust acquisition. So the 1983 Tilley-Hardwick judgment requires mandatory acquisition for certain types of property. In this particular case, the Buena Vista Rancheria, the tribe had been terminated and the lands were given in fee to two members of the tribe, Louis and Annie Oliver, as joint tenants in 1959. Their daughter and their surviving child conveyed her interest to a Miss Potts, who then was the spokesperson for the tribe in 1996. Later in 96, the tribe attempted to exercise the mandatory trust election under the 1983 judgment by conveying the lands to the Bureau of Indian Affairs. The Bureau of Indian Affairs returned the deed and instructed the tribe to go through the discretionary acquisition process. In 2010, the tribe once again requested that the BIA take the Rancheria land into trust pursuant to the 1983 stipulated judgment. In 2008, the Bureau of Indian Affairs informed the tribe again that they should resubmit their application as a discretionary application. The tribe then appealed the Bureau of Indian Affairs decision to the Interior Board of Indian Appeals, and on request from the BIA regional solicitor, the Interior Board of Indian Appeals remanded the matter back to the Bureau of Indian Affairs. Bureau of Indian Affairs issued a final decision in October 2020, once again determining that this should be a discretionary acquisition. The court found differently, however. The court granted the tribe's motion to enforce the 1983 Tilley-Hardwick judgment and ordered the Bureau of Indian Affairs to effectuate compliance with that. Navajo Nation versus Department of Interior. So this is the Navajo Nation challenge to the Bureau of Indian Affairs taking land into trust for the Hopi tribe. In 2010, the Navajo Gaming Enterprise purchased land east of Flagstaff, where it planned to construct a casino. That same day, in order to gain access to Interstate 40, the enterprise entered into an easement with the adjoining landowner. This was a perpetual, non-exclusive right to a 500-foot easement to the enterprise and the public. In 2012, the Hopi tribe purchased the land from the underlying landowner, the adjoining underlying landowner, including the easement. Not the easement itself, but the land underlying the easement. The warranty deed that conveyed the land to the tribe subjected the land to matters of record in the official records of the county recorder's office and explicitly acknowledged the enterprise's easement. The Hopi tribe submitted the Feeder Trust application to the BIA pursuant to the Navajo Hopi Land Dispute Settlement Act of 1996. The application also acknowledged the Navajo Gaming Enterprise's interest in the easement. In 2014, the BIA took the land into trust. In 2015, the Hopi tribe asserted that it had jurisdiction over the easement, and the Navajo Gaming Enterprise disagreed. It does not appear that the Hopi tribe, though, ever blocked access to the easement or blocked people's ability to cross via the easement. The Navajo Nation sued the Bureau of Indian Affairs over the Bureau's taking the land into trust for the Hopi tribe. The court here dismissed the case for lack of standing. The court found that Navajo Nation could not show any actual deprivation of a property right, so there was no concrete or particularized injury that is fairly traceable to the Bureau of Indian Affairs' decision to take the land into trust. Okay. And that is all. My name is Sarah Lawson. Again, I am of counsel with Schwabe, Williamson, and Wyatt in Seattle, Washington. And I thank you all for your time and your attendance at the Tribal Land Staff Conference.